the right to presumption of innocence would have been violated. The right to liberty of the person would have been violated. The right to dignity of that person would have been violated. And of course, the right to movement, because when that person is held down and detained by the mob, and then not the violent mob in that situation, because it couldn't have been peaceful, he can't move around, and then wouldn't have his liberty to be able to move around. So those, even the right to fair hearing, are you really in any position to try this person to get a balanced view of the position of this person? Even when some may allege that in such situations, perhaps before they actually exert the mob action on the person, that they may have inquired to probably find out the guilt or otherwise of that person. But you don't have the right to determine the guilt or innocence of any person. And even the right to be tried only by court, right, has also been denied, because the mob group isn't a lawful group and not a court to determine the guilt or otherwise of this person. So in all considerations, it is condemnable. It is not an act that is justified in any way. The world over, it's not only on the ground that is violating the rights of the victim of mob justice, but it's clearly also in violation of the provisions of the law with respect to either trying a criminal suspect or even of punishment, because there is no such provision in any law that provides that punishment shall be that kind of jungle justice, so to speak. So it wouldn't really fall within any of the prescriptions for punishment, and it does not also justify or satisfy the philosophy of punishment in any way. Even the state agents, that is the police or any arresting and detaining authority or investigating authority, that they also saw someone in the act of committing an offense, they do not have the power to determine that that person is guilty of that offense. It's surprising, but yes, even those, it is not in the power of the police to even determine that the person they saw who hit another person to death has committed murder. It is not, because if it were so, then the police would have just sentenced that person and taken to the correctional center.
But Ekine, this one is difficult to swallow. While I understand your position as a human rights, we know a killer when we see one, right? And I know that we will have to be careful in addressing this person using the word alleged, calling them suspect. But while the court would need to determine guilt, we know it's somebody that has killed another person. We know.
Then gather the evidence and present it before the court. You can imagine the logic. Now, why then would the law require that you still take this person to court, even when everybody around, eyewitnesses, actually saw when Mr. A hit Mr. B and Mr. B slumped and died? And let us even assume that even when police officers were around and they saw that this action of Mr. A actually led to the death of Mr. B, why wouldn't they just take him to the station and send him to the correctional facility and say maybe the DPO or the commissioner of police, not even the inspector general of police, can pronounce punishment to that person, even if he saw it himself, to say you are now sentenced to death? No, you would still take this person to the court and charge the person on that appropriate offense. What would probably aid him in establishing that alleged offense, even when sin in the scene is alleged, is the presence or the availability of his evidence and witnesses, credible and reliable witnesses and evidence that he would take to court and present. I was there when Mr. A hit Mr. B. He hit Mr. B with a club on his head on the backside, and Mr. B slumped and died. It's credible, very weighty evidence. And then one or two corroborating, and then with probably pictures and video, it will be a short trial even, and then the court may probably find him guilty. But you'll be surprised that there will still be defenses, because you may not know the circumstance in which that other person, Mr. A, hit Mr. B. You will not know the state he was, whether he has any exculpating element that will probably excuse him.
Okay.
You wouldn't know. So for you and me and this passerby who say Mr. A hit Mr. B, but are you sure the mental state of Mr. A that hit Mr. B at the time?
So,
are you sure whether he did so on provocation that is reasonably defensible.
Okay.
Are you sure whether he did that on some influence of alcohol or intoxication?
Okay.
Does he have any criminal defense at all? These are issues the court will look at again.